Hello everyone, I hope you're having a good day and you're staying safe. I'm Sesa Gill, a legal intern at LEXIS and Company, and today I'm going to be talking about false imprisonment as a tort. Now, wrongful imprisonment or false imprisonment occurs when a person who does not have the right or justification intentionally restricts another person from exercising his or her freedom. When someone intentionally restricts another person's freedom, he or she can be liable for wrongful imprisonment in civil court and criminal court. The factors that contribute to false imprisonment are plaintiff's knowledge of the imprisonment, possible cause of imprisonment, and intent to of the defendant during the imprisonment and confinement period matters. Now, it is applicable in both private as well as government detention. Under criminal law, whether the restriction is total or partial, the same is actionable. Now, when the restriction is total and person is prevented from going out of a certain confined limit or subscribed limit, the offense is that of wrongful confinement, as defined in section 340 of the IPC. Under this, the Indian Penal Code punishes wrongful imprisonment and section and under section 339 to 348. When it comes to the police providing false imprisonment is sufficient to obtain the writ of habeas corpus. It is not mandatory for that a person should be put behind bars, but he should be confined in an area which from which there is no possible way to escape except the person's will who has confined him. Depending on this law of a particular jurisdiction, wrongful imprisonment can also be a crime as well as an intentional tort. Now, I'm going to be talking about the elements of false imprisonment. First is witchful detention. Now, false imprisonment or restrict must be intentional and witchful. Accidentally closing the door on someone is not the other side. On the other side is not a wrongful confinement or false imprisonment. Witchful detention applies to intentional restriction in any form, including physical restriction and a person from exiting, physical locking him in the building, rooms, or from another place and restricting him from leaving other forces through other forces. Now I'm going to be talking about the intentional factor. So generally, if we talk about false imprisonment it must be intentional, right? A person is not liable for false imprisonment unless he or she has acted in a way for the purpose of imposing confinement or with knowledge of such confinement to a substantial certainty, which results from it. Now, for this tort, malice is irrelevant. It is ordinarily upon the judge to determine from the evidence that from the evidence as a question of fact the intention of the defendant in action of the false imprisonment. Now, the fourth element which is essential is knowledge of the plaintiff. The detention of the other person would have been wrong And there is no requirement that the plaintiff claiming another person of false imprisonment was aware of his restrict on his freedom and at the time of his confinement. This generally means that the plaintiff should have a knowledge about his restriction. Otherwise, if he doesn't, it cannot be identified as false imprisonment. Now, I'm going to be talking about a few of the landmark cases which have landed upon false imprisonment and have changed some of its laws. So, the first case that I'm going to be talking about is Bhim Singh versus the state of Jammu and Kashmir. In this case, the petitioner, then an MLA of Jammu and Kashmir, was to participate in the assembly meeting. His opponents, in order to prevent him from attending the meeting, the assembly session, got him arrested wrongfully with the help of some executives and police. Now, the magistrate also granted redeem to the police without complaint of the mandatory requirement of the production of the accused in the magistrate court before redeeming him to the police custody. He was he was released after the assembly session got over. The Supreme Court held that the state is liable for the wrongful arrest and detention of the petitioner and ordered a commission of 50,000 to be paid to the commissioner. Now, the second case that I'm going to be talking about is Rudal Shah versus the state of Bihar. Now, in this case, the petitioner was under trial and was wrongfully confined in jail for several years despite his acquittal by the court. Now, the High Court of Patna held that as soon as a person is under trial and is not found guilty by court, he should be set free. Any detention if it shall be lawful. The state had to pay him a sum of 30,000 as well as compensation. So I hope this was an interesting topic and you got to know about lawful imprisonment. Unlawful imprisonment and about false imprisonment, of course. And I hope this was an interesting topic. Thank you so much for watching.